Good morning. Welcome to Real Estate Tips. I'm Wayne Russell, instructor, broker associate with RE/MAX Southwest, Sugar Land, Texas. Most of the information that we discuss will come from newspaper articles, magazines, and emails from different sources. Before I get started on my outline, I wanted to always look at the business page, whether it's the Fort Bend Community Extra or the Chronicle or something, just to keep you abreast of what's going on in your area. Right here, the hospital project on schedule. Construction is well underway at Memorial Hermann Sugar Land Hospital. Work on a 6-story, 155,000 square foot patient tower is on schedule for completion in September 2016. And the 100,000 square foot Medical Plaza 2 building is scheduled to be finished by November of 2015. The $93 million expansion of the Memorial Hermann Sugar Land campus began in May of 2014. And the project marks the first major development project at Memorial Hermann Sugar Land since the campus opened in 2006. Okay. Also, I wanted to, a lot of the agents in the office brings me attention to different things, so I just wanted to acknowledge their efforts. So one is, here's one that one of the agents gave me in regarding FHA loans and then FEMA. This is an email from one of the title companies here. FEMA has recently declared Fort Bend County to be in a disaster area due to the recent rains and flooding. Because of this, we're now requiring final inspections for all properties that have already been appraised, just to prove there was no storm damage after the appraisal was done. This will be mandated by FHA now and will be required for completion of the loan. We're ordering this today for your home, and I'm sorry to say there will be an additional cost of $125 for this inspection. I'm sorry we didn't have to do this. It is out of our control. This shouldn't take long to complete, and it won't interfere with your closing unless damage is found. So it's always something new coming up. I just wanted to bring that to your attention. And the next one.
Okay, break that down. Is that a certain period of time, all homes that are sold in a certain period of time?
Well, you know, FEMA's going to insist that the house be inspected to make sure there's no damage in this particular scenario. Now, I don't know how long it's going to take an effect, but this is just the most recent one. I got this from one of the title companies here, and Elba was the associate that handled this transaction. So this is just one of the emails I got.
And it's on FHA?
Mm-hmm. FHA. It didn't say anything about conventional, didn't say anything about everything else. I only mentioned FHA. So be prepared for your buyers to always pay a little extra for additional inspections. Okay.
I guess my concern is I have one closing in about a week and a half.
Well, tell your buyer.
They might be told they have to do this now.
Your mortgage company or / title company may be calling you.
Interesting. Okay.
The next one was just wanted to. Let's see. I have another email from another agent here, and she talked about TRID. Let me explain what TRID is. Let me just go back a little bit. It's also the breaking news for CFPB, which is Consumer Financial Protection Bureau. They're going to extend things to August, from August to October, but let me get into that in just a second. Essentially, August the 1st rollout date will not happen. At this point, CFPB has said it will aim for October the 1st roll-around instead. Actually, it's October the 3rd. But anyway, at the moment, that's not finalized. Stay with American First Home Mortgage for updated information. Anyway, what is TRID? It stands for TRID is the TILA-RESPA Integrated Disclosure Rule. Let's start over again here. TRID is the TILA-RESPA Integrated Disclosure Rule. Only in the mortgage world would we make an acronym out of acronyms. So anyway, so let's break this down a little further. The TILA is the Truth in Lending Act, and RESPA is the Real Estate Settlements Procedures Act. The CFPB modified both rules in its TRID final ruling. Anyway, I just want to bring it to your attention if you see the word TRID. Okay. Okay, on the outline today, I'm going to discuss The proposed amendment to delay the effective date of CFPB, MLS agent can avoid sending listing to MLS. Are MLS agents who do not use MLS to sell properties, also known as pocket listings, still required to disclose the final sales price? How can an owner obtain sales price of comparable properties? Who pays for the title policy? Deed restrictions. Do I need to update my seller's disclosure, create new restrictions, buyer representation agreement, broker being sued, questions liability for agents agents' actions. As is provision, I'll cover that. What does it really mean to a buyer? Home is not in a platted subdivision, trying to put land on a trust. And I'm also going to, if I have enough time, we'll try to cover code of ethics, just the very beginning of code of ethics.
So if there's a pocket listing, how do you get that, how do you disclose the closing price? Do you go in and just, not active, but put it in the MLS?
Well, let me go a little bit further on that. Let's just say the owner says, like I have a pocket listing now. And so, but the owner says, I have a buyer too. And so, I want you to take care of the paperwork. I'm not going to disclose to you what fees I'm making, but he says, I don't want it in MLS. So I'm going to cover that in just a second, so just bear with me here. But pocket listings, apparently you don't have to, and you sell them according, let me go a little bit further, but you don't have to disclose that because you don't have it loaded in MLS.
Right.
So, I mean, if you don't have authorization to
Isn't that saying it needs to now be disclosed?
Well, let me answer your question in just a second,
Okay.
so let me get to that.
Oh,
I was
there's
just
more to
going
come.
over the outline, so let me get to that in
Okay,
just a
I'm
second,
with
and
you.
I'll answer the question.
Okay.
One thing at a time here. So CFPB, that's Consumer Finance Protection Bureau, proposes a 2-month extension of the know before you owe mortgage rule. The Consumer Financial Protection Bureau today issued a proposed amendment to know before you owe mortgage disclosure rule, which proposes to move the rule's effective date to October the 3rd, 2015. The rule is also called the Telerespa Integrated Disclosure Rule. You know, I just got to going over it again. Anyway, it requires easier to use mortgage disclosure forms that clearly lay out the terms of mortgage for a home buyer. The Bureau is issuing proposals to correct the administrative error that would have delayed the effective date of the rule by at least 2 weeks until August 15th at the earliest. The CFPB is proposing new effective date of Saturday, October the 3rd. The proposal will be open to public comment until July the 2nd. And so, anyway, I'll let you read the rest on your own. MLS agent can avoid sending listing to MLS. Most of you are realtors. At one time, for the first 20 years, I was an independent broker. But in the last, I've been licensed in '68, so the last X years, I've been a realtor. So, but
You're
before that, I was an
licensed in
independent broker. Right. One of the agents that I used to come to my class was at 1868. I said, no, it's...
Did they even have real estate then?
No, you were, I'll get to that too in just a second. How does MLS agent avoid sending a listing to MLS? The only exception that we know of is seller sends a written communication to the brokerage firm informing the listing agent that the seller does not wish to market his property through MLS. The listing broker must get the signatures of the seller and certify this waiver by filing an HAR Form 300 entitled Seller Authorization to Exclude Listing from MLS. And I just happen to have it right here. It's a Form 300. If they don't want to put the, the information in MLS, and it states at the bottom in item 5 that it could be on a temporary basis or a permanent basis.
How do you sell it if it's not on the MLS?
Sell it yourself.
Then why hire a broker?
Well, it's a lot of people, a lot of times owners don't want to put signs in there,
Yeah.
don't want to put lock boxes on there, shown by appointment. You have to show the house, even through other agents. They don't want to put information in MLS, yeah.
Could be because it's in an area where if it's a vacant property, they don't want people necessarily knowing it's a vacant property.
Whatever reason, if the seller doesn't want an MLS, this says seller authorization to exclude listing from MLS.
So you don't put it on MLS at all?
Right.
How would you sell it then?
Well, you may sell it by word of mouth.
But you,
or by a sign on the property.
Like
you mean as far as how do
standing
you
on the
finish the
street and
trend?
trying to sell it? How
Hey,
does
I'm
that
just,
work?
I'm just going by the newspaper article.
Are you asking how do you go through the paperwork process?
Yeah,
You do it just like you normally would, just you don't have an MLS number.
how do you get a buyer?
You may have your own buyer.
Well, what if it's a
Okay.
FISBO that calls you up and says, hey, can you do the paperwork for me?
Or you may have enough just internal marketing.
Or you may walk up to the sell, now I've had a situation where I was working with a buyer, and the buyer goes, we were driving down the street, he says, boy, I sure do like that house over there. I said, why don't you walk up to the door and see if they're thinking about selling? So you walk up to the door and say, yeah, I've just thought about selling, but I don't want to list it, I don't want my neighbors to know what I'm doing. Do you have a buyer? Oh yeah, he's in the car. Would you pay me a 10%, I mean, a 6% commission? Excuse me. So, you know, whatever you want to work out, okay? So, also too, in the listing agreement itself, under item 6 in the listing services, you go to C, and it says right here, I know that you always read your listing agreements from A to Z,
Yes.
the 17 page, no, I'm sorry, 10 pages, and you always read every word in the deed of trust, which I doubt very seriously. Anyway, this says broker will not file the listing with multiple listing service or any other listing service. So that box probably will be checked. And I'm handling a transaction right now that we just happen to check that box. And it's already under contract, the inspections have been done, the appraisal's been done, and so we're gonna close pretty soon.
So are you representing the buyer also? Both?
And not in this scenario, I'm just representing the seller, because I only have a listing agreement. Only reason why you represent a buyer, if you have information about broker services with the buyer, you're representing the buyer, are they a client or a customer? They are a customer.
If you do have or don't have.
If you have information about broker services signed, they are a customer. And if you have the buyer's rep, they are a client. So you ask the question, I got both sides. To a degree, I'm the only agent involved, but the buyer did hire an agent that he's going to pay on the side. It's not even in the contract, to a degree. So, anyway, it's the first time I've had this, so I'm representing the seller, not both sides of the transaction. Okay. Everything is negotiable. Okay, let's go for it, let's go. I'm buying a house in a subdivision that has deed restrictions, but there is no owners association that we can find. Are the deed restrictions still good if there is no one to enforce them? You bet. Anyone who claims the benefits of deed restrictions can enforce them, so a neighbor can sue to prevent a violation. I'll let you read the rest of that on your own. I've had my house on the market for several months and it just recently flooded for the first time. Do I need to update my seller's disclosure form? You bet. We suggest you do so. The statute doesn't require it, but there's a material change in the disclosure and you don't update it, the next buyer may not be so happy. So do the right thing. A subdivision is old and deed restrictions have expired. We want to maintain the integrity of the subdivision and create new restrictions. How do we go about it? Believe it or not, there's a statutory provision for doing this. Get a copy of the Texas Property Code and read the sections on deed restrictions. I remember some years ago I was talking to someone in the West University area, and their restrictions were about to run out. So, you know, everyone got together and extended the restrictions for another 50 years. So, you know, if you had property, say, on Bissonnet or something that had commercial potential, you think, and you could tear the house down or, you know, use it for commercial. If they extended the restrictions, then it's still single-family residential use. Okay. Anyway, I visited a real estate office and asked if they could help me look for a house. They said they couldn't help until I signed a buyer's representation agreement. They quickly provided one, which I signed. Then they showed me a few houses and had a short talk, and I went to my apartment and wasn't very pleased with their service. I read the buyer representation agreement and it has a term of 2 years. What do I do now? You're held to a duty of care and having an understanding everything you sign. Oops, In this situation, however, your agent owes you a fiduciary duty of 100% disclosure and has a duty to put your interest ahead of his, or ahead of the agent's. It sounds like you didn't do that at all. File a complaint with the Texas Real Estate Commission and let them investigate you. We bet this is not the first time this agent has tried this. Okay, the next one is brokers being sued, questions liability for agents' disclosures. In other words, let's just say you sell your own house in this scenario, and you didn't receive any fee because you sold it yourself and found a buyer and closed on the transaction. So I gave this to the broker to make sure that, you know, when we should have a policy in our office when we sell our own house and there's no agents involved and you mess up. So I'm a Texas broker. One of my agents just sold his own house. I received no commission, was not involved in the sale at all. Apparently there was a misrepresentation made by that agent and I just got sued. This is like the broker, you know. How can any of this be my fault? You sponsored that agent, trained that agent, and hopefully mentored that agent. You're responsible for everything he or she does as an agent. The fact that you receive no compensation isn't a factor. My guess is that he or she use your office business cards and telephones during the sale and check with your errors and omissions insurance carrier. You may not even be covered. All brokers in our opinion should have a written policy outlining these situations. Okay. The next one is
You can see why I am happy to be no longer a broker of record.
right. Well, the broker has responsibility. In fact, to be a broker, I understand that you have to have 10% interest in the company to be the designated broker. In our scenario, I believe it's 50-50 with Jennifer and Betty. Anyway. As is, there's a long line of Texas cases that hold as is means the buyer is taking title without representations from the seller other than representations as to title. Practically speaking, it puts the burden on the buyer to do inspections of all types, pest, termite, mold survey, provided by other professionals. If there are defects, the buyer has those other professionals to pursue, not a seller who has moved away, is broke, and passed away. In other words, I've gone over this several times in previous classes, but 7D1, as is, period, end of sentence. Now, you have an option period to negotiate repairs during that option period. If you don't negotiate repairs, don't try to do it after the option period because you're buying the property in its present condition, period. So, anyway, 7D1 is as is, and of course you have the right to renegotiate the contract during the option period. I'm handling the transaction right now where they bought the property as is, and then the option period was 7 days, and they didn't ask for any repairs on the midnight of the 7th day, and so therefore they're buying the property as is. Okay, hey, we're going along here. I bought a home in an older area of Houston. When I went to get a loan, I was informed that it was not in a platted subdivision. They couldn't guarantee my boundary lines. Is this going to be a problem in the future? What have I bought here? Believe it or not, unrecorded subdivisions are not uncommon in Houston, especially in older areas where they may have developed subdivisions based on drawing in order to sell to consumers as quickly and cheaply as possible. Chances are great that the streets have been in use for years, have been implied and dedicated to the public, and long possessory use by prior owners have established indefilable boundary lines. Get a good surveyor, establish your boundary lines to the satisfaction of the title company. Title company likely will give endorsements to your lender to work this problem out. Pick a good title company with national underwriter. I know that one of the agents right now, I think, is dealing in a subdivision that's they provided a survey and a T-47, but the title company wouldn't accept it. It was in this kind of scenario, so they had to order a new survey. And so, if you're dealing in older subdivisions in Houston, you can come across that. I doubt very seriously it happened in say, First Colony area. It's only, they started, I think the 1978 is when they started the Highlands in First Colony. So anyway, I'm trying to put a land on a trust for the benefit of my kids and grandkids. I told her I can't convey it to the trust. Why not? The trust doesn't take title. It must be conveyed to the trustee of the trust. They are given the authority to act on behalf of the trust for the benefit of the beneficiaries of the trust. Okay. We're moving along here. Let's see. I think I jumped from not having and not giving authorization to put the listing in MLS. Let me go back here. Our MLS agents who do not use MLS to sell properties, also known as pocket listings, still required to disclose the final sales price. And you asked Todd the question, and it says no. So this is what we're on. This is the page I had to go back to because, anyway. It says, I'll repeat that, our MLS agents who do not use MLS to sell properties, also known as pocket listings, still required to disclose the final sales price. The answer is no. However, an agent belongs to MLS, the agent must follow the rules of MLS and comply with them. If the property sales price is excluded from the MLS, one could have to obtain any sales data that may be available from HCAD, which is the Harris County Appraisal District. How can an owner obtain sales prices of comparable properties? If the owner is represented by an agent who belongs to MLS, check the MLS listings of comparable properties. It's usually accomplished through a comparative market analysis. Otherwise, if you're not using a realtor, check the appraisal district for comparable properties. And the last one here is yesterday I closed on a home. This is really confusing because I've seen on closing statements where they mention title policies about 2 or 3 times and you go, who's paying for what? You know. Anyway, I wanted to go over this. Yesterday I closed on a home that has been paid off for years. The buyer had an FHA loan. On HUD 1 form on page 1, line 209, it states seller credit for owner's title policy, and it had an amount of $1182. Yet on lines 509, seller credit for owner's title policy, I was charged $1,182. Also, I understand that there's the set farmer, but my question is, do both parties have to pay the title insurance? Seems like a lot of money going to the title companies to have something issued and get charged twice for it from the seller and buyer. Bottom line, does the seller have to purchase title insurance if the home has been paid off? Well, check again. It is customary for a seller to pay for title insurance. I'd say over 90% of the time the seller pays for the title policy. There's always exceptions to the rule. It is customary for a seller to pay for title insurance in Texas. The Real Estate Settlement Procedures Act, which is RESPA, is a federal law that requires the buyer to pay for title policy as part of the buyer's settlement costs. We then credit the buyer for that cost on page 1, so the seller ends up paying for it. Only one policy is paid for and issued, as agreed in the contract for sale. Sorry for the confusion, but the forms are from the federal government, and they are here to help you. This is their effort to simplify closing costs. Go figure. We wish we could make this simpler, but we scratch our own heads from time to time. Okay, so yeah, because you'll see the title policy on there, and really the seller's paying for the title policy as per the contract. Now, I've had one situation where the buyer paid for the title policy, and he just reduced the price. He was getting reimbursed from his company for all expenses, so he says, well, how about throwing in the title policy? He said, okay. So he had a list of all the expenses, and it would say it was $100,000, and the title policy is close to 1%, so the sales price is $99, but we put in there buyer paying for title policy, so net proceeds, that's the same difference. Okay, one of the agents asked me to talk about code of ethics, so I've got a whole book right here on code of ethics. So I'm just going to go over that briefly. And so we're on this page right here, 101 of Code of Ethics. And it says, before we talk about Code of Ethics, let's think about the ethics in general. Check the boxes you think describe the idea of ethics. They're all, you know, law and legal matters, religious beliefs, philosophies and philosophical beliefs, standards of conduct, morals and personal beliefs, industry codes, honesty, integrity, and doing the right thing. That's all Code of Ethics. Anyway, when you check any of all the boxes you found, synonyms for ethics. Ethics can be defined in many different ways and can be subjective to personal morals and beliefs. The Code of Ethics was adopted in 1913. Before then, the real estate industry had a history of speculation, exploitation, and disorder. There were no real estate licensing laws. Real estate practitioners, if licensed at all, were licensed as peddlers. Anyway, ethics, the code of ethics fits into a big picture of ethics as the industry code. You'll see the code sets objective standards with all realtors and agree to follow their real estate practices. I'll let you read the rest on your own. The Realtor Code of Ethics, the Code of Ethics was created to establish a standard of professional conduct for real estate practitioners. It is based on the concept of service. Let the public be served. Underlies the entire code. Protection of the public is the ongoing basis for the code. Many of the principles established in the code were later incorporated into the state licensing laws. Many judicial decisions rely on code of ethics as a standard of conduct for real estate industry. While alternative dispute resolution systems, including the arbitration and mediation, have become popular in the course of recent years, the code of ethics has required realtors to arbitrate their disputes since 1913. And the Realtors Code of Ethics. Remember, the code and state law conflict. The code always yields to the law. Laws differ from state to state, so always check with your legal counsel if you have any questions about whether you can conduct conforms to the law. And this is a real quick quiz here. It's just a little over a page long. The idea of ethics can mean morals and personal beliefs, industry practices and standards, religious beliefs, and philosophical beliefs, and the answer is all of the above. At the time Realtor Code of Ethics was adopted, there were no real estate laws. When real estate license laws was established, state legislatures looked to the Code of Ethics as the source of standards for the real estate industry. The Code of Ethics was adopted to establish standards of conduct for the industry. And alternative dispute resolution has been mandated since the Code of Ethics was adopted. So anyway, just as I said, I want to touch on the Code of Ethics if we have time in our classes. I was talking to one of the agents in the office about the Code of Ethics, and just, you know, watch what you say to customers, clients, and other realtors, and don't talk negative about another realtor if they don't return calls, if they're procrastinators and they want to delay and they're waiting to the last minute to negotiate repairs. Bite your lip, bite your tongue. Just don't say anything negative. If you got something positive to say, great. But if you got something negative, just because you might get into a little trouble. Anyway, y'all got any questions? Tell you what, thanks for coming, and I'm glad you enjoyed the breakfast, so we'll see you in a couple of weeks.
Thank you.
Very good.
You're welcome.
Amen.